Okay, let's explore this. Today we're digging into a really fascinating and frankly incredibly impactful Supreme Court decision, Hewitt v. United States. It just came down June 26, 2025. And this deep dive, it's really all about how the precise meaning of a word, just one verb, really, and how that interacts with legal ideas can literally cut centuries off a prison sentence. You'll definitely walk away with a clearer picture of how these complex legal debates happen and why every single word in the law matters so much. Now, to really get what Hewitt means, we kind of need to step back. Back to how things used to be. Imagine a system, a federal system, where one single trial could result in someone getting like hundreds of years in prison just for firearm offenses. It sounds wild today.
It does sound wild, and it was the reality.
Mhm.
It revolved around a specific law, 18 U.S.C. Section 904C. Basically, it criminalizes having a gun while committing certain other federal crimes. But the key thing before 2018 was how sentences were handled. Judges had to impose these incredibly harsh, stacked sentences, even for first-time offenders under this specific law.
Stacked. What does that mean exactly?
Right. So this came from an older Supreme Court case, Deal v. United States, back in '93. It meant, okay, for your first Section 924C conviction in a case, you got a mandatory 5 years. Okay. But then for every other Section 924C count, even if it was all part of the same crime, same incident, same trial, you got a mandatory 25 years added on top, consecutively.
Wait, 25 for each additional one.
25, each one. So you can see how these sentences just ballooned. Decades, even centuries, like the court said. I mean, look at the people in this case, Hewitt, Duffy, and Ross, their initial sentences, over 325 years.
Each. 325 years. That's
Yeah.
that's hard to even process, especially for a first-time offense situation under that law. So if someone used a gun, say during 3 related robberies charged in one go, they'd be looking at 5 years plus 25 plus another 25. So 55 years mandatory minimum.
It's exactly right. 55 years, just from those Section 24C counts, on top of whatever sentence they got for the robberies themselves. And it was that kind of outcome, that perceived disproportionality, that really fueled the push for change.
Okay, so that sets the stage. Things were pretty severe. Then came the change.
Then came the change, yeah. Thankfully, Congress acted in 2018. They passed what really was a landmark bill, the First Step Act. It did a lot of things in federal sentencing, but for our purposes today, Section 403A is crucial. It basically clarified, that's the word they used, that judges didn't have to impose those stacked 25-year sentences on first-timers anymore. It effectively overturned that deal case. So now it's a 5-year mandatory minimum for each count, even for subsequent ones if you're a first-time 924C offender.
Okay, so it destacked the sentences for first-timers. That's a huge difference right there.
Huge. But then there's the question of who gets the benefit of this change. That's retroactivity. Usually changes like this only apply going forward to crimes committed after the law passes.
Yeah.
But Congress did something different here. Section 403B, it's titled Applicability to Pending Cases. And this part made the lower sentences partially retroactive. It said the new rules apply to any offense that was committed before the date of enactment, if a sentence for the offense has not been imposed as of such date of enactment. That last bit, has not been imposed, that's the million-dollar phrase here. That's what this whole case hinges on.
Right, has not been imposed, which sounds simple, but I guess it gets complicated fast. So how did Hewitt, Duffy, and Royce get caught up in this specific wording? Their crimes were way before 2018, right?
Way before. They were convicted back in 2009, got those initial 300-plus year sentences. Then they appealed, went to the courts. In 2012, actually, their sentences were vacated on appeal for certain reasons. The district court resentenced them, still to very long terms, like 285 to 305 years.
Okay, so they had been sentenced twice, even, before the First Step Act.
Exactly. That's key. But then, after the First Step Act passed in 2018, another legal development happened. A different Supreme Court case, United States v. Davis, came out in 2019. It basically said the definition of crime of violence used for some of their specific 924C convictions was unconstitutionally vague. This gave them an opening. The appeals court, the Fifth Circuit, let them file new post-conviction motions. And here's the critical point. The district court then vacated not just those specific convictions affected by Davis, but their entire sentences. Poof. Gone.
Whole sentence wiped out.
The whole sentence. Wiped clean. So now they come back for a new resentencing hearing, after the First Step Act is law and after their previous sentences have been legally nullified. And their argument is, hey, our prior sentences were vacated. Legally, they don't exist. So as of right now, a sentence has not been imposed on us. We should get the new lower 5-year minimums from the First Step Act.
Makes intuitive sense if vacated means gone, but the lower courts didn't buy it.
The district court didn't. They reimposed the old, stacked 25-year minimums, still resulted in huge sentences, over 130 years each. And then, on appeal to the Fifth Circuit, something interesting happened. The government actually agreed with Hewitt and the others. They said, yeah, the First Step Act should apply here. But the Fifth Circuit still said no. They denied the joint request. Their logic was basically, you guys were sentenced back before 2018, multiple times in fact. The act says has not been imposed, and, well, a sentence had been imposed historically, vacated or not.
So that set up the big question for the Supreme Court, this Edge case. Sentence before the act, sentence gets vacated after the act, now facing resentencing. Which rules apply? The old harsh ones or the new First Step Act ones?
Precisely. That's the knot the Supreme Court had to untangle.
And Justice Jackson, writing for the majority, untangled it in favor of Hewitt, Duffy, and Ross. How did they get there?
Yeah, the majority sided with the petitioners. They said the Fifth Circuit got it wrong. Their reasoning really rested on two main ideas. First, they dove deep into the grammar. That phrase has not been imposed. They focused on the verb tense, the present perfect tense. They argued it doesn't just point to a past event, but implies something that continues to be true or relevant now in the present.
Okay, so not just was imposed at some point, but is currently in a state of having been imposed.
Kind of, yeah. Or rather, is currently in a state of not having been imposed. The absence continues. Justice Jackson used this analogy. Think about the Olympics. Imagine the rule is, you can call yourself an Olympic champion if a gold medal has been awarded to you. Okay, a sprinter wins gold, medal awarded, but then, oops, doping violation, medal stripped. Can they still say a medal has been awarded to them in the sense required by the rule? The majority says no. It was awarded historically, but its legal status, its validity now is gone. It has not been awarded in the present relevant sense.
That's a helpful analogy. The past event happened, but its current legal effect is nullified.
Exactly. And that ties directly into their second main point, the legal meaning of vacatur. What happens when a court vacates something? The court leaned on a really fundamental legal idea. When a court order, like a sentence, is vacated, it's considered void ab initio, Latin for from the beginning. Legally, it's treated as if it never happened. It has no ongoing legal force.
Like hitting the undo button, legally speaking.
Much like it never existed.
Yeah.
So they used another example. Imagine a law gives stimulus checks to anyone who has not been convicted of fraud. If you were convicted, but that conviction got overturned, vacated on appeal, are you eligible? The majority says yes, because the vacated conviction is treated legally as no conviction at all. The slate is wiped clean.
Okay, so connecting those 2 points. If the sentence was vacated, it's legally gone, void from the start. Therefore, at the moment of resentencing, it's legally true that a sentence has not been imposed. Is that the logic?
That's the core logic. The vacatur wipes the slate clean, meaning the conditions set by Congress in the First Step Act that a sentence has not been imposed is met at the time of the new sentencing. Therefore, the more lenient First Step Act penalties apply.
And the court felt this wasn't just technical grammar, but fit with what Congress was trying to do.
Absolutely. They stressed this wasn't some hyper-technical loophole. They called it a common-sense understanding that aligns with Congress's clear goal in the First Step Act. Remember, the act was a direct response to years of criticism about these sentences being grossly disproportionate, shockingly harsh. Judges, sentencing bodies, they'd all condemned the old stacking rule as irrational, inhumane, absurd. Congress wanted a clean break.
So the majority saw applying the First Step Act here as fulfilling that intent.
Right. They argued Congress didn't want full retroactivity. They weren't reopening every old case. But Section 403B, the pending cases part, was meant as a middle ground. It was designed to capture anyone who still needed sentencing after the act passed. And that includes people like Hewitt, whose prior sentences were nullified and were now standing before the judge needing a new sentence imposed. Plus, they argue this interpretation is just more practical for courts. Going forward, any judge sentencing a first-time Section 924C offender just applies the new rules. Simpler, avoids weird disparities.
Okay, that lays out the majority view pretty clearly. But as you said, not everyone agreed. Justice Alito wrote a strong dissent. What was their take?
Yeah, the dissent, led by Justice Alito, came at this from a very different angle. They thought the majority basically twisted the law to get the result they wanted. Their main point was about history. For the dissent, imposed simply means pronounced. Did a judge at some point in the past pronounce a sentence? Yes or no? For Hewitt and the others, the answer was clearly yes, multiple times in fact. The later vacatur, in the dissent's view, doesn't erase that historical fact.
So they're saying the past event is fixed, immutable, regardless of later legal actions like vacatur.
That's the essence of it. They argued a sentence in the law should just mean any sentence ever imposed, not a currently legally valid sentence. They pushed back hard on the majority's grammar argument, saying the present perfect tense can just refer to a completed past action. And they really didn't like the Olympic analogy, thought it was flawed and context-dependent.
What about the whole vacatur wipes the slate clean idea? The dissent didn't buy that either.
Slaked. Not at all. They basically said that sweeping void ab initio principle the majority relied on. It does not exist in this context, or at least not in the way the majority used it. They pointed to other Supreme Court cases, like Lewis v. United States. There, the court said a conviction for being a felon in possession of a firearm could stand based on the historical fact that the person had a prior felony conviction at the time they possessed the gun. Even if that prior conviction could have been challenged or was later invalidated, the historical fact remained relevant for the felon in possession charge.
So historical fact trumped later legal nullification in that case.
In that specific context, yes, according to the dissent. They also cited another case, Bravo-Fernandez, where a conviction that was later vacated still had legal relevance for something called issue preclusion, basically preventing relitigating a specific factual issue. And they argued, look, Congress knows how to actually wipe the slate clean if it wants to, and it didn't do that here. They pointed to another sentencing law, 18 U.S.C. Section 3742G1. That law explicitly tells judges, when resentencing someone after an appeal, to use the sentencing guidelines that were in effect at the time of the original sentencing, not the current ones, which suggests Congress doesn't always treat the original sentence as if it never happened.
That's an interesting counterpoint. What about the pending cases title of the section? Did the dissent make anything of that?
They did. They argued the title, Applicability to Pending Cases, strongly suggests Congress was thinking about a specific, limited group of people. Those who simply hadn't gotten any sentence yet when the act passed. The majority's reading, they warned, creates this potentially endless group of people who might become eligible years down the road if some future court decision vacates their old sentences. It's not really about cases that were pending in 2018.
And they also brought up the general rule about laws not applying backward, right? The presumption against retroactivity.
Yes, that was another key plank. Criminal laws usually only apply going forward unless Congress makes it crystal clear, expressly provides, with plain import, that they should apply retroactively. Any doubt, any ambiguity, the dissent argued, should be resolved against retroactive application. The majority's interpretation, they felt, stretched the text too far to find retroactivity.
So from a policy standpoint, the dissent just saw this as the court overreaching.
Pretty much. They accused the majority of marching in the parade of sentencing reform, basically letting policy preferences override the text. They called the outcome an entirely undeserved windfall for these petitioners, suggesting maybe the district court didn't even need to vacate the entire sentences in the first place. They saw it as maybe just a lucky break for Hewitt and the others, not something Congress actually intended to cover with the First Step Act.
Wow. So really fundamentally different views on how to read the statute, the effect of vacatur, and maybe even the role of the court in interpreting reforms like this.
Absolutely. It highlights that deep divide in legal interpretation text versus purpose, historical fact versus present legal status.
So when you step back from the legal arguments, what really stands out to you from this deep dive into Hewitt?
You know, what really strikes me is how these arguments, which can sound incredibly technical, almost academic, debating verb tenses, the precise legal effect of vacatur have such immense life-altering consequences. I mean, the difference between the majority and dissent's view, it literally meant decades, more or less, prison time for these individuals. It just powerfully illustrates that legal interpretation isn't just a theoretical exercise, it shapes lives. And it shows how our understanding of laws and maybe even justice itself can evolve over time.
Yeah, that's a crucial takeaway. The abstract legal debate had profoundly concrete results here. Hewitt v. United States really does show that interpreting the law, wrestling with specific words, historical context, legal principles directly impacts people's futures and how we define justice. It reveals this tightrope walk judges have, sticking to the words Congress wrote, but also understanding the problem Congress was trying to solve and applying it fairly. And it leaves us with a really interesting question to chew on, doesn't it? As society's views on things like sentencing change, how does the legal system balance sticking with past decisions versus fixing outcomes we now look back on and see as, well, unjust? Where do you draw